Hi guys, it's Kathy. I hope you're doing well. We made it to Friday. Yay, Friday. So today we're going to start with a friend of the court docket, and then we'll see where we go next.
Have a seat, kind of scoot up a little bit. All right, this is in the matter of Megan Sue. Do you pronounce it Ruger or Rugger?
Ruger, ma'am.
Okay, versus Anthony Lloyd Ruger, file number 23-50368 DM. So, Mr. Ruger, you must have, oh, here we are. Court arraignment. So, all right, Mr. Ruger, we are here on a bench warrant that was issued for failure to appear for a show cause. It states here that you have a monthly order of $1,327 in child support as of the show cause originating June 9th of 25. Thank you. Looks like you had an arrearage of $20,431.82. At the show cause of June 9 of 25, you failed to appear. This is a second show cause. So I don't show. Okay, it looks like the last payment we received was $317.36 back on December 15 of 2024. Let's see. All right, so Mr. Ruger, the address we have for you is the house number is 13225. Have you moved from that address?
I just moved, but all my mail is still going to that address because it's my parents.
Okay, so Mr. Ruger, do you understand it's a crime to fail to pay child support?
Yes, and I also this is not an excuse, but I didn't look through my pay stubs, and my place of employment was not taking child support out. I mean, I know it's not.
Well, hold on, Mr. Ruger, just stop talking for a minute. Now, Mr. Ruger, do you understand it's also a crime to fail to appear in court when you're ordered to do so?
Yes.
All right. Now, Mr. Ruger, you understand you could be facing up to 45 days in jail if you plead guilty or found guilty of failure to pay child support and failure to appear in court.
Okay. Yes.
Yes?
Yes.
Okay. Now, Mr. Ruger, are you currently employed?
Yes, Your Honor, I am. Yes.
Where?
Buck Brothers Asphalt and Paving in Toledo, Ohio.
What's their last name? Loft, L-O-F-T?
No, it'll be Buck Brothers Paving and Asphalt.
Can you spell Buck?
B-U-C-K.
B-U or C-U?
B-U-C-K.
Okay. Do you have that, Ms. Pam?
Yes, I do. Thank you, Your Honor.
Okay. All right. Mr. Ruger, you know you're supposed to pay $1,300 a month in child support. I find it very difficult to believe you didn't realize your child support was not coming out of your check. I mean, I noticed they take too much out of taxes. So I would think you would notice if they didn't take $1,327 out of your child support. So I think you were just thinking if they didn't take it out, it wasn't your problem. But the problem is now you have an arrearage at the felony level where the Attorney General can charge you with a 4-year felony, and you could be facing up to 4 years in prison, and they won't release you unless you pay 20% of it. Do you understand that?
Okay.
Okay. So, Mr. Ruger, you do have a right to have an attorney represent you at this and all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
Yes.
All right.
Well,
do you know the phone number for your employer so Ms. Cam can call right now and verify your employment?
It's actually, it's not off the top of my head because it's on my cell phone, but I know they do have a website where you should be able to get a hold of one of my, we have 2 office ladies there.
All right, so Ms. Cam's gonna look into that, and then we're gonna hold on a minute until I can get a court-appointed attorney for you, all right?
Okay.
And Ms. Cam, if you could maybe call and try to verify his employment, they should be open. They open early for asphalt paving, so. All right.
No, thank you, Your Honor.
All right, Mr. Ruger, just bear with us. Okay, so we have a couple things in the matter of Kathleen Joe DeLine versus John Hiram DeLine III, file number 22-49188DM. First thing we have is a show cause. Mr. DeLine has an order to pay $1,011. As of today's date, the arrearage is no, at the time of the original show cause, it was $2,769. As of today's date, it is $4,034. We did receive a total of $756.21 in payments since the last show cause hearing. The last payment being $252.07. I'm sorry, on October 1 of 25. So we do have an income withholding, but they are not meeting the monthly requirement. And we didn't receive a payment in August. In September, we received a payment totaling $504. So Mr. DeLine, friend of the court, wanted you to know that if you're working at a different job, you probably need to have an income review done. Do you understand that? Did you file for one?
I have not. I'm also remarried and have young children living.
I don't really care. So you have to, I mean, you got to afford these and you went and have more. Okay. But they're not your biological children, are they?
No.
Yeah, they're not your kids. So you need to petition for a friend of the court referee hearing for an income review.
Your Honor, he did in May of 24, and he did not turn in the required paperwork, so he has to wait until 27.
He can pay. He can pay.
Yeah, but for the review.
Yeah, well, there's a free one every 3 years, but he could do one once a year if he wanted, if he's willing to pay for it.
Oh, okay. Gotcha.
Yeah. So the free one's every 3 years. So you're probably gonna have to file a petition,
Okay.
pay, show up, and bring all your financial documents in. And if you showed up last time and didn't bring your stuff, they wouldn't have changed it. You understand that?
I didn't know that.
Well, you gotta figure it out. You gotta learn it. So, okay. So is this the only child support case you have?
Yes.
Okay. Okay. All right. So then we're back on. All right. So I have notes that you will pay July and August and pay child support. She was making payments on the TLC. I think that's all taken care of, or no?
What's that?
The TLC account?
Yes, and he made the monthly reimbursement payment to me this.
Okay. Okay, good.
Yeah.
So you owe a lot of money, which is why it's important that you do the friend of the court referee hearing, but that also means you got to bring in your pay stubs and all that paperwork, because otherwise they're not going to be able to do anything. So we have the Christian Brothers Quadro. Has that one been settled? What are we waiting?
Oh, wait, yeah, that's all settled.
Okay. And then, so we're just waiting on the military one. And what are we waiting on?
I am in contact with them. I have an appointment at 10 o'clock this morning to speak with the person at DFAS that is supposed to be taking the divorce decree and applying this for me. I have been working since we were here on the 8th, trying to find the number of who I needed to get in touch with to get this taken care of. I have an appointment with that person at 10 o'clock this morning.
Where's that appointment at?
It's a phone call, video appointment with DFAS themselves. And he's supposed to give me his email to send the divorce decree to get this taken care of.
Because we don't even have a quadro for the military one yet, right? Okay. Do those terms make sense to you, DFAST and all that?
DFAS, no.
No? What does that stand for?
Department of Finance for the military.
Okay, thank you. Okay. All All right. Any other updates?
That's about it. You really need to. Oh, sorry, that's about it.
Thank you.
You're welcome.
Mr. Murphy, are you here for the front of the court show causes?
Yeah, yes, Your Honor.
All right. Do you have the paperwork on Mr. Ruger?
I guess I can look up on the defender data.
Yeah.
Uh,
Becky would have sent it to the public defender this morning.
yeah, I mean, I don't,
No,
there's-
Miss-
it's
Miss
not emailed
Adams?
to me.
I'll forward it
Mr.
to you,
Murphy,
Mayor.
we were advised to mail it to the PD thing. So hold on, Miss Adams.
I will forward it to him right now.
Okay. thank you.
Okay. So I'm going to put you two in a breakout room so you can talk to him. All right.
All right, thank you.
All right. All right, so, still waiting on that, and the last payment we received, so we're getting some payments, but we're not getting the full amount. So
I'm not getting
understand,
the full amount. I need to know more info on that because, it's 250 that comes out of my weekly paycheck. Are
okay,
they getting that? That's coming out.
you get paid every week?
I get paid every week.
All right, Miss Cam, can you verify if that's coming out every week?
Give me one moment to look it up.
Cause I am.
Hold on,
they-
let her look it up, hold on. Give me just a minute, have her look it up.
Toby Construction.
Yes,
Yes, there was a payment. October
Can you
1st.
tell me how many weeks we've received a payment?
It looks like it's consistent. Since September, we have had 3 payments.
So, have you gotten those yet?
I've gotten two, so I'll probably get the.
So it looks like the 250 or whatever is coming out every paycheck, so that's good. All right, Miss Adams, I only want like 30 days, a date to figure out if he's sorted out the pension.
We looking on a FOC show cause time or?
Motion time is fine too, Robert, because I need at least 15 minutes, but a Monday morning's fine too.
Okay,
So, Mr. DeLine, it's incredibly important that we get this done.
yes.
So I don't care what you gotta do,
Yep.
figure it out.
Yep.
And then, petition for a child support review if you need to, but you gotta provide documentation. Understand, you can get married to someone with 6 kids. It doesn't mean you don't pay your child support for these.
I'm not saying I don't, and, you know, actually probably when the review should have happened, I'm making $10 less an hour than when this went through court in the.
Right, which is why you have to do the income review. But if you don't do it, we don't reduce it, right? So that's fully on you. And, you gotta, you know, follow up on it. You don't get a free one, but you can get a paid one at this point. Yeah, I mean, you can pay to have an income or front of the court referee.
That's just a $100 petition, right?
I don't know. It's been a long time since I paid that for my clients, so I think it sounds about right. You can just go to the clerk's office and ask when we're done here. All right, Miss Adams,
how about November 17th at 8:30?
November 17th at 8:30. Could I get a notice of hearing for them?
Yes.
All right, so we're gonna adjourn this over to November 17th at 8:30. And the whole issue we're gonna be here on
It's the military.
is military pension. All right, and then that will make sure everything is taken care of. And then, you know, obviously you're making your weekly child support payments, so I'm happy. But if you want to have it reviewed, you can pay to have a petition filed and do that, all right?
All right, thank you, ma'am.
So stay right there and we'll get you a notice of hearing and then hopefully it's all taken care of when we come back. All right, Mr. Murphy, have you had a chance to speak with Mr. Oh, and on the front of the court thing right now, Ms. Kim, I'm gonna dismiss it because he's making payments.
Okay,
No, not yours, Mr. Murphy. So in the matter of Megan Ruger versus Anthony Ruger, file number 23-50368 DM. So Mr. Murphy, I know I appreciate very much that you're filling in this morning. So Mr. Ruger is well above the felony level for the amount of child support. He's like double the amount. He failed to appear on June 9th. The address we have on record is his mailing address at his parents' home. We have made, like, the last payment was $317.36 back on December 15th. So how does Mr. Ruger wish to proceed today?
Your Honor, from my understanding, he was asking the court to, if we could address bond, if it's possible to reduce the bond amount. Again, obviously, Your Honor is aware. I wasn't quite sure because I don't deal with these. I'm kind of confused sometimes
So
about if
he
it's a
has
felony charge. So I
choice.
understand.
He can plead guilty or he can plead not guilty.
Well, he's gonna, from my understanding, he doesn't want to plead guilty at this point to the failure to appear on June 9th, unless I'm mistaken on that. If he wants to plead guilty, obviously, I guess, you know, he can say so right now, but my
Well,
understanding
there's
was.
a failure to pay and a failure to appear. So is he gonna plead on the failure to pay?
He didn't say he wanted to plead on anything, Your Honor. He just wanted me to
Do
address
you want
bond.
another breakout room with them?
If he wants to plead today, I guess we can address that, because all he wanted me to do was address bond.
Here.
Mr. Ruger, I'm sorry, we weren't picking you up.
Oh, I told him, I was just curious about, well, I can get the $5,000 bond.
So the first thing I want you to do is decide whether you want to plead guilty or not guilty. If you plead not guilty, we can proceed to trial right now if you want, because we have your caseworker here and she would testify as to whether or not you made payments, okay? If you plead guilty, I will sentence you today, and yes, I will set an amount of 5,000 paying out. So typically, Mr. Murphy, if they plead, I sentence them immediately, and then I do set amount for them to pay to get out of jail, because obviously we're much more interested in that. And the front of the court is asking for 5,000. So if he decides to plead today, I would then say, you know, sentence them usually, and this is just an example, I'll say 30 days in Lenawee County Jail, but we're much more interested in receiving payment. If you'll pay $5,000, you can be released. Otherwise, you'll serve the full 30 days. And then on the failure to appear, he did advise the court, though, that that is his mailing address he uses for his parents. But if he pleads to the failure to pay, I'm less worried about the failure to appear.
Thank you, Your Honor. Could I just have a brief breakout with him for a few minutes?
Yep, I'm gonna open
Thank you.
up that breakout room.
Oh, don't tell Josh. Don't. Kelly, I swear to God, if you tell Josh, you're the one. You're just going to tell Josh as soon as he walks in, hey, Josh, guess what? Listen, about signatures, about autographs. I gave you guys a task not too long ago. I said, guys, take your foot, take a pen, and write your screen name with your foot on a piece of paper. And then we were going to guess who wrote which one. So far, I got about five. Okay? I'm not going to do it today. I'm going to do it tomorrow. So you have time to take your foot and put a pen in between your toes. Write your name with your toes. And then just take a picture of the piece of paper. To make myself very clear, I don't want a picture of your foot. Please don't send me foot pictures. I want a picture of the piece of paper with that you have written your name in with your toes. And we're going to see if we can all guess who wrote which one tomorrow. So you have time to do this. And then pop it into Discord. Send it to me in Discord. All right? It'll be fun. I hope. Yeah, I can read a bunch of them, so I wonder if they're faking it. But I only got 5 so far. There's an autograph for you. Yeah. It'll be fun though, Brett. Please don't send me foot pictures. Just the paper.
Miss Cam, is Ruger yours?
Actually Jeff's, but I'll do it today.
He's here. There was
Yeah.
no name at the bottom of it, so I didn't know, but Jeff Anderson is here.
Yeah, we were.
There he is.
I'm here.
I'm adding
So I
his
think-
income withholding right now.
Huh?
I'm adding his income withholding right now as I wait.
All right.
That's way better, JK. But we noticed from the OJ trial that you can't even draw a hand. That people can't even draw a hand. So drawing a foot would be. You guys missed it in the OJ trial. They drew a glove, and the fingers are all mangled on this glove. It was outstandingly hilarious. We almost tinkled a bit when we saw it. So funny.
Oh, I'm sorry, Mr. Murphy. I didn't realize you were back.
No, I just got back.
All right, we're back with Mr. Ruger. So, Mr. Murphy, how would you like to proceed?
John, at this time, Mr. Ruger would like to plead guilty to failure to pay at this point.
All right, so, Mr. Anderson, at this point, I'll get a valid address, but I'll dismiss the failure to appear and I'll just proceed on the failure to pay, all right?
Yep, that's good.
All right, Mr. Ruger, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, excellent. Thank you. You can put your hand down. So we've gone through this, but you understand it's a crime to fail to pay child support to the very best of your ability up to the amount ordered. Do you understand that?
Yes, Your Honor.
And do you understand that if you are, if you plead guilty, I could send you to jail for up to 45 days. Do you understand that?
Yes, Your Honor.
You're entitled to have a trial and you cannot be convicted unless the evidence that the trial proves that you are guilty beyond a reasonable doubt. Do you understand that?
Yes.
You're entitled to have an attorney represent you here today and in all subsequent proceedings, and I've appointed Mr. Murphy to represent you. Are you satisfied with Mr. Murphy and the advice that he has given you?
Yes.
All right, you're entitled to have all the witnesses against you appear at your trial, and you and your attorney would have the right to question those witnesses under oath. You're also entitled to have me order any witnesses you might have to appear at your trial on your behalf. You do not have to say anything at your trial, and if you do not testify or say anything, nothing will be held against you, and in fact, no one will even mention your silence. On the other hand, do you understand that you are entitled to testify at your trial if you want to testify? Do you understand that?
Yes.
How do you plead to the charge that you failed to pay child support to the very best of your ability up to the amount ordered?
Guilty.
All right. So, Mr. Ruger, in this case, you are ordered to pay child support. How many children do you have with Ms. Ruger?
Just 2.
2.
I have
Okay.
2.
All right. And you were ordered to pay $1,327 a month in child support. Is that right?
Yes, that's correct.
Okay. And as of today's date, you have an arrearage of $20,431. Now, Mr. Ruger, you made a payment back on December of $317.36. How did that payment get made? Did you make that payment?
To be 100% honest, I don't even remember paying it December because I was laid off in November.
Okay. Where are you currently employed?
Buck Brothers Paving and Asphalt.
All right, Jeff, she was verifying, oh, Kelly, Miss Cam, were you able to verify his employment?
I was.
And he is
got it.
employed there?
Yes.
Excellent. So we will be setting up an income withholding for there. Now, would you agree that you have not made payments since they were ordered in this case or your divorce became final?
I agree.
Okay. All right, and you were working at certain times during that time period, correct?
Correct. So I went back to Buck Brothers the first week of April.
Okay, and you didn't make an April payment, you didn't make a May payment, you didn't make a June payment, you didn't make a July payment, an August or September, is that
Holy shit,
correct?
That's terrible.
That is
Thank you,
correct.
Linus. Thank you. Thank
Okay.
you.
All right, so you have a very high arrearage, so I don't think you understand, but understand it's very important that you pay this down steadily so you don't get charged by the AG's office, all right? The Attorney General in Michigan, like I said, will charge you, all right?
Okay. So
Okay,
I can
and-
also make payments on the portal, correct, ma'am?
Can
So,
you
like,
say
if I
that
have-
again? I'm sorry. It kind of broke
No,
up.
you're
It's
fine.
not your fault. It's that room. It's horrible. Go ahead.
So like you set the payment arrangements up and it comes out of my check. Like if I have an extra decent check, I can also make payments on the portal for that week too, correct? Like if I had, I could double up, or you know what I mean? I could make the full payment, then put like an extra $100 to $200 through the portal.
That would be perfect. So yes, you can do that. All right. Okay. And what is your address, sir?
Mine, 13.
Where do you want your mail going to?
13225 County Road H, Waseon, Ohio, 43567.
Okay. All right. I accept the plea. It has been given understandably, voluntarily, accurately, and knowingly. You have full knowledge of your rights. Is there anything, Mr. Murphy, you'd like to say on behalf of Mr. Ruger before the court passes sentence?
Your Honor, I'd ask the court to consider, I understand what you had said previously. I understand that there was a bond discussion of $5,000. I think Mr. Ruger just didn't understand the situation. It was no nefarious intent or malicious intent. I think he has every intention moving forward to make good on his obligations. I'd ask the court to consider maybe having him be released with less than the payment of 5,000. I don't know if he right now, if he can come up with that. I think he just wants to be out working and trying to get this paid off as quick as possible. But whatever the court decides to do, I'm sure he's going to make, whatever arrangements he needs to make good on it. So, and Your Honor, just a minimal, amount is what I was asking court to consider.
Okay, Mr. Ruger, is there anything you want to say in your own behalf?
Not really, no. I take full responsibility for what I did.
So, Mr. Ruger, going forward, every paycheck you get, check it. If they didn't take that money out, make that weekly or bi-weekly payment. Do you understand?
I understand.
Okay, and you said earlier someone would be able to pay 5,000. Is that correct?
I was in contact with my mother last night, and she said she was waiting for the bank to open at 9, and I was going to call her once I got out of here to make sure she got the 5,000.
Okay, well, she's gonna have to go to the bank and get it. It's sent to the court. It will serve 14 days in Lenawee County Jail. We're much more interested, obviously, in receiving child support payments. If you pay 5,000, you could be released. Otherwise, you'll serve the full 14 days with credit for, I think you've been there 2 nights, right?
Yes.
For 2 days. All right. So, yep, as soon as your mom pays that, you'll get released, okay?
And I do have one question, Your Honor. Where
Yes,
does
sir.
she need to go? Where does she need to go to pay that? Does she need to come to the basement of the court or to the jail?
Mr. Anderson, is it quicker to go to the FOC and pay it or the jail?
I'm guessing it'd probably be quicker to go to the jail.
Yeah, have her go.
You sending your mom to jail, sir? Sir, don't send your mom to jail.
Go to the jail.
Okay.
Okay, thank you.
Thank you.
Mr. Murphy.
You're welcome, Your Honor. Thank you.
Thank you.
Okay. We are going to move to Lakewood, where everything is slow. But I haven't seen Judge Mansfield in a hot minute. So, these are new attorneys too. So maybe they aren't as slow as they used to be. But Washington is always slow. Hold on.
In the Nisqually jail.
Yeah.
Morning, Your Honor. For the record, Drew Larson, appearing for the defense. It appears that we have Mr. Paul McCarthy here with us. One of the case numbers before the court today is 25L004813.
All right, and I see that we also have another matter too, 25L005293. They both appear to be before us today on a competency issue, if I'm not mistaken. So, counsel, how are you asking to proceed this morning?
Yes, Your Honor. We are here before there are competency issues in this case. Last time we were before the court, which I believe was Monday. Sorry, my apologies, Your Honor. Friday, January 9th. There was discussion on the record regarding a competency evaluation that Mr. McCarthy was supposed to have done while in custody. That, as of Friday, that evaluation had not been completed, and we were approaching the 14-day statutory threshold on having that evaluation done. And speaking with Mr. McCarthy today, it does appear that an evaluation was completed yesterday. However, defense counsel has not received any report regarding said evaluation. Yeah, we're still waiting on that report, Your Honor. I don't know if prosecution or the city has received that either, or if the court has received it. But what I can let the court know today is that defense counsel has not received any sort of report yet.
All right, so counsel, are you asking then to set this matter over? And if so, how long of a continuance are you seeking?
Well, Your Honor, first and foremost, we would ask for a dismissal in this matter, given that it does not appear that the evaluation was timely completed within the 14-day threshold. Alternatively, Your Honor, we would ask for Mr. McCarthy's release today, and a set over of the next hearing to discuss competency with him out of custody, Your Honor.
Okay, and I'll hear now from the city.
The city is not able to respond to whether or not the,
Oh, sorry, if you could, I don't believe that you're on Zoom. If you could just pop the video up. Thank you. Okay, and is the city prepared to address the issue of the timeliness of the evaluation and completion and any potential motion to compel?
no, Your Honor. However, it does appear that that issue may have been heard on January 9th. There was a motion to continue uploaded to add time for the competency evaluation. Defense objects. It was reset for competency evaluation. So other than what's in the docket, it looks like this objection has already been heard once and the court set it over. I just asked that the court follow Judge Lewis on the 9th, asked us to be set over 1 week.
And as to the request for release today on personal recognizance, what is the city's position?
City would defer to the court.
I'm sorry, could you repeat that?
The city would defer to the court.
Okay. Is there anything further from defense?
Nothing too substantive, Your Honor. My understanding was that the set over that was granted last week for the competency evaluation was for today. And my understanding, Your Honor, is that today was the day that we were going to address whether or not the competency evaluation had been timely completed. Defense's position is that it was not, given that even if an evaluation was completed, which it sounds like it may have been yesterday, that would fall outside the 14-day statutory window. And furthermore, Your Honor, we have no report of said evaluation yet.
Your Honor, can I say something?
Sir, you have counsel appointed. At this time, I'm going to recommend that you have a conversation with your attorney outside of court. So first I'm going to address the issue of timeliness. I do see some indications that there was an objection as to the evaluation that was noted by defense on January 9th, 2026. That being said, I believe the competency statute does permit defense to bring up issues of timeliness once that 14-day window has elapsed. For purposes of today, though, I am not going to dismiss the cases. I am denying defense's request without prejudice. And I'm going to indicate I'm denying it without prejudice because there is a process the defense can follow as to competency evaluations. Now, typically, the court understands that that is when a competency evaluation does not actually occur within that 14-day window. And there is a process by which Western State or other mental health facilities can essentially be interpled into the court to address that. I do not have any briefing before me today, or any case law that would allow me to make any decision as to whether the statute and case law would permit this court to dismiss a case when a competency evaluation has occurred prior to a review on competency, but the physical evaluation itself has not been emailed to the parties. So again, I am going to deny defense's request, but that is without prejudice as to that component.
Hi, Lisi.
Good for you.
As for the request, for Mr. McCarthy to be released, at this point, the court is assured that he has obviously complied with the competency evaluation. I have reviewed his case history as well as the FTA warrant history. And at this time, I am going to release Mr. McCarthy on his personal recognizance, promise to appear. I'm going to order that he abide by all previously imposed conditions of release, including remaining in contact with his defense attorney, informing the court of any change to his address or phone number, and updating any changes to his mailing address, residential address, or phone number with this court, as well as the Department of Licensing. And I am going to keep this one on a shorter turnaround. So I am going to set this for a hearing on the motions calendar on January 29th, 2026 at 3:00 p.m.
I'm sorry, what was that date again, Your Honor?
January 29th at 3:00
He can see you all, just so you know.
p.m.
Thank you.
Hi, Nisqually Jail. He should have. Jude.
All right, the motion to continue is saved and it should be ready for the parties to review and sign.
He's going to need more than a report if he does that, T. So this is Washington. It's just slow. They do.
And to clarify, that is an in-person hearing. So the defendant is required to personally appear.
Don't worry, we're going somewhere much faster in a second. A psychologist, huh? We should talk.
Is there anything further from either defense or the city on this matter?
Nothing further from defense, Your Honor.
I don't even know why you're there, defense.
I have attached my signature to that form, Your Honor.
And is there anything further from the city?
No, Your Honor.
Okay, with that, this concludes this matter. So we're ready to call the next case.
No, no more. No. No. No more. Please. No more. Yep.
This hearing. So, Kiara Owens, y'all probably have to reach out to her and tell her that if she still believes that Mr. Coleman is a threat to her, she would need to request a protective order from the appropriate Superior Court.
I'll let her know. We'll reach out, Judge. Thank you.
All right, thank you. And I'm sorry, Mr. White, so do you so stipulate at the present time?
We do, Judge.
All right. Mr. Coleman, have you consumed any medicine or alcohol recently?
No, ma'am. But I had something to say though.
No. There's nothing.
It is something to say, like.
You can't do anything. You can't help yourself in any way.
I'm not trying to help myself, but I want to make sure that y'all understand that I got a 12-year sentence in the feds. Like, this could have been.
Stop.
Yeah, about no Kiara Owens.
It doesn't. Then don't worry about it. It's time served. You're done, and there's nothing that you need to address the court with. Only bad things could happen by doing that.
I'm gonna speak for myself. I don't care.
Do you want to accept the plea offer?
I'm still gonna state what I want to state though.
Mr. Coleman, you are represented by defense counsel, Mr. Tom White. And I assume that you've already spoken to Mr. White about your 2 misdemeanor cases in state court.
Yeah, they could have been resolved.
If you decide to accept the plea offer today, that would close these 2 cases out. And then the only other matter that I can see is your U.S. Marshal hold.
I'm ready to get there. I'm tired of this. This is stressing me out.
So, if you'd like,
I plead guilty and I'm ready to get out y'all way, please.
you won't be released. You will be released to the U.S. Marshal hold.
He understands.
I'm very aware of that, and that's what's making it stressing right now because I know this could have been resolved. I've been locked up going on 5 years.
Mr. Coleman, again, have you consumed any medicine or alcohol recently?
I got great sense.
And have you understood what's going on in your 2 cases today?
Yeah, that they could have been resolved.
Are you satisfied with your attorney?
I plead guilty. I'm ready to go.
I appreciate the fact that you are stressed out and frustrated, but if you don't let me do my job in order to ascertain whether you are entering a plea that is knowingly, voluntarily, and freely, I will reset this case for another day, another time. So will you let me do my job without interrupting and simply answering the questions?
Yes, ma'am.
Yes or no?
Go ahead.
Thank you. Are you satisfied with your attorney?
Yeah.
And have you understood that if you decide to plead guilty to these charges, you would have to give up your right to a trial? You will not go back to a courtroom to face a judge or a jury. You will not be able to confront your accuser. You will also not get the opportunity to present any legal defenses and arguments to the jury, and the state won't have to carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these constitutional rights?
Yes.
How do you plead to,
Guilty. Guilty.
Let her finish. Let her finish.
how do you plead to terroristic?
Guilty.
Let her.
All three charges.
If you interrupt me one more time, I will reset this case to the end of the month. Do you understand? Yes or no?
Yes, you asked me to do how I plead, and I said guilty.
I haven't completed my sentence.
Oh, okay. I wasn't aware of that.
How do you plead to 2 counts, terroristic threats and simple assault from March 26, 2022?
Guilty.
How do you plead to simple battery, family violence from December 3rd, 2021?
Guilty.
For the terroristic threats, your sentence is 12 months to serve 30 days, credit for time served, balance suspended. With regards to the simple assault, it's 12 months concurrent with count 1, balance suspended. For the simple battery, family violence conviction, the sentence is 12 months suspended. That concludes your 2 cases. You will be released to the U.S. Marshals hold as soon as they arrive at Fulton County Jail. Thank you.
Thank you, Judge.
Thank you. To proceed?
We are, Judge.
Okay. This is David John Horst, convicted of battery family violence in case number 23CR0037768. He's got a probation violation case where a warrant was issued, and this is from June 13th, 2025, case number 26PV039. Officer Allen with the probation office, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. And what was the reason a warrant was issued?
Your Honor, the defendant failed to report to our office. He's failed to complete the 40 hours of community service as well as the family violence program. Your Honor, it looks like he's reported at least 2 times to probation, where he was given the information to enroll into the domestic violence program. And at some point, Your Honor, he did stop reporting to probation. It is 213 days remaining on his case. He has now been in custody since December 16th of 2025. And again, Your Honor, I did notice that he has a hold out of Birmingham, Alabama.
All right. And what's this, and the state is, the probation is deferring to the court.
Your Honor, because of the time frame remaining on his case, he will be somewhat shy of maybe 1 or 2 weeks of the program. But if he's going to be transferred to Birmingham, unfortunately, he would not have enough time to complete that 24 weeks of domestic violence.
Okay.
I can address that, Judge.
All right. Mr. White?
Actually, Mr. Horst has already completed 22 of the classes, so that's not going to be an issue. Additionally, we don't expect any, there's a high likelihood that he won't be going to Alabama. He is out on bond on a case there. It is pre-conviction, obviously, and he does have a private attorney that's working on that. And he's been informed by that attorney that the extradition matter is corrected and he should not be going to Alabama. Obviously, I cannot guarantee the court that. But the fact that he's already completed 22 classes, he was reporting. He did go out of state for work. He did try to report by phone, but was unable, was unsuccessful in that, obviously. We're just asking that you reinstate him on probation and allow him to complete the final 2 classes in his community service. Plus, he's been in jail a month now, Judge.
Has his probation ever been amended to allow telephonic reporting?
No, Your Honor. And also I will add, as far as the domestic violence, although he's completed 22 of the 24 programs, Your Honor, because of the state requirements, he will have to start over. He's not going to be able to continue on and complete those 2 classes.
He's completed those 22 classes while being incarcerated. So he is on course to finish.
Which school did he go? Or which school did he do the program?
I'm not aware.
May I have the name of the school?
Oh, okay.
Does your client know the name of the school?
He's been doing it while incarcerated.
Understood. So he has to sign up somewhere on a website to do the classes. What's the name of the website of the school?
Path of Education. It's here. It's offered into the tablets that we have. I've been using my time here to do those courses. So when I sign in and log in with my ID number and all that, that's where I found all that stuff.
And how many classes did you complete while you were at the Coney County Jail?
There's over 100, there's hundreds of them, but I focused on the self-awareness and the domestic violence and a little bit of the substance abuse, anger management. I tried to focus on those.
Okay, so this is not a formal DBIP program where it's consistently 24 weeks where you attend every class once a week. So it's not a program that you've enrolled in. You just pick a class and do it.
Yes, ma'am.
Okay.
And Judge, you don't have to attend those classes in person anymore. You can do them online.
That I do know, Mr. White, and I also know how DBIP works.
And my point is that it's not necessarily weekly. He can, if the class is being offered in his next stage, he could conceivably do that in a couple of months.
Let me get one thing clear with everyone. When an individual is sentenced or ordered to do a domestic violence program, that means enrolling in a formal domestic violence accredited program. And it also requires the individual to report to probation in person unless otherwise ordered. Now, I'm not about to engage in piecemeal sentencing where the defendant gets to choose how they want to carry out their sentence. So, Mr. White, I understand the substantial compliance argument, but I'm not about to allow an individual to do his probation based upon what he thinks is best for him, or what is more accommodating for him.
That's not what we're asking, Judge.
That's precisely what you're asking. You're telling me to accept his ability to sign up for classes, whichever that's available at the jail, because he thinks that complies with his DBIP probation condition.
Judge, that was not my point at all. My point was that he is taking active measures, still has plenty of time to complete the course.
No, he doesn't. He has 213 days, and he still has to report to Alabama. There is absolutely no indication that he has been excused from the Alabama case. And I understand your frustration, Mr. White, because you've only had a brief conference with him. But what I do have before me is an individual who did not report, who chose to report by telephone. That's absolutely no evidence.
He did report for the first two, he says for the first 3 months.
Well, hallelujah.
2 months. Judge,
I am going to, go ahead, sir. Anything else before I rule?
Judge, we're not arguing that he was properly complying with probation, but we do have this all the time where he was making more of an effort than most and has tried in the last month to get caught up. There is plenty of time, even if, as I was saying, on the DVIP, if he does that online, he could probably complete that within a couple of months, because you don't have to go once a week. There are different levels going on all the time, and as long as he is compliant, he could complete that within a couple of months. Additionally,
what is the case holding him in Alabama? Is it a misdemeanor, a felony?
It is a felony.
Was it acquired during his probation term?
As I said before, Judge, he's been out for 2.5 years on probation on that case. I mean, on bond of that case. So that case has been open for about 2.5 years.
Officer Allen, when was he convicted of this battery DV case?
Your Honor, he was sentenced on January 15th of 2025.
All right, thank you. Anything else, Mr. White?
No, Judge.
Thank you. I have very little faith in the fact that Mr. Horst will be able to comply with the strict conditions of his probation. I'm going to revoke the remainder time of his probation, give him credit for time served, And once he has completed the remainder time where the Fulton County Sheriff will give him 2 for 1, then he may be released to Alabama because he has a fugitive hold from Alabama. And once he's completed his obligations here by completing his jail time, then he will go to Alabama and complete whatever obligations he has in Alabama. Thank you.
Your Honor, that concludes my business. May I be excused?
Yes.
Thank you.
Unbelievable.
So Alan, I shoplifted once because of self-checkout. I didn't know. I had forgotten the eggs were right under my purse. I put the eggs in the top part so they wouldn't break. And then I slap my purse down on top and I go through the self-checkout and I buy everything and I grab everything out of my purse and then I just walk out the door. And I was too terrified when I was in the parking lot and I picked up my purse and I saw the eggs. Too terrified to go back in. I thought I was going to jail. So I jumped into my car and I left. And I took the eggs. Yep. But that's because of self-checkout. I'm not qualified. I'm not qualified to run one of those. Will you stop, please? All right. You know, the jerks that go to restaurants, whatever. The real polite people that go to restaurants, whatever. The people who make servers' jobs the easiest is when you go to a restaurant and you sit down and then when the server comes to your table, you order food from the menu, you order a drink from the menu. That's it. The server stands there, you say, I want this one and this drink. Even if it's special, it doesn't matter. Even if it's, I want this one with no onions and extra pickle or whatever, that's fine. As long as you just, when she gets there, you just tell her your order and then she can leave. Like, you give her order and leave. But the ones that make you stay long to listen to jokes and the ones that make you stay long to listen to complaints, those are equally bad because we don't have time to care for either of those things. We have to get to the next table as soon as possible because that next table is waiting and if they have to wait 5 minutes, we're in trouble. So yeah, the ones who just, can I just have this and this? Yes, sir. Coming right up. Thank you. They make our day. Oh, you've been to a restaurant before. I don't know what I want to drink. Yes, you know what you want to drink. You absolutely know what you want to drink. Oh man, I can't. It's right in front of me, guys. Don't worry. I thought I lost this judge. I really like this judge. There is one annoying feature of this judge, though. So I'm going to do a little bit of switcheroo real quick. Because trust me, you'll get annoyed. What I want to do is cover this because it continually flashes. It doesn't stop. It goes from English to Spanish, Spanish to English. It doesn't stop. It's so annoying. I'm trying to watch a court video. That's good right there. You'll see a little bit of it flash. But it keeps drawing your eyes over there. And the main event is the judge. He's just so, I just love this judge. This is only the second time I've seen one of his dockets. I don't know if he just started streaming or if I'm just way out of the loop. Wait, I can't read that. I want to take away Twitch for a sec. Victor, it's Villarreal? Victor Villarreal? It's in Webb County, Texas. Right? Texas. Yes, I see the star. Here we go.
Mr. Garcia.
Your Honor, this is, I believe, Mr. Montemayor's motion to.
That is correct, right?
Filed November 24th, right, Mr. Montemayor?
Your Honor, this is a motion for enforcement and clarification of the final decree of divorce. This court signed a decree on June the 9th. It was agreed to by all the parties. And in that decree, the parties agreed that within 90 days of the decree being signed, that Ms. Albesa Duran was going to pay Mr. Duran $85,000 for his interest in the homestead, which is located at 3406 San Salvador here in Laredo Webb County. He would in turn sign over a warranty deed to Ms. Duran, waiving or giving her his interest in the property. We've come obviously a little more than 6 months now. It's been over 180 days, and there's been no payment by Ms. Duran to Mr. Duran, and so we're here now asking the court to want to clarify the decree, because the decree failed to include the language of the sale should she not comply. So we're asking the court to allow us to clarify the decree and allow us to get a realtor involved and sell the property by way of enforcement of this decree. So that's why we're here, and I don't believe that there is an objection to it. I think it's just a matter of getting a realtor involved. And in the interim, Ms. Duran can still come up with the money. We'll still be willing to sign that deed over.
Mr. Montemayor, before I ask for a I apologize.
Su señoría, estamos aquí para una moción para clarificación debido a que el decreto de divorcio se firmó el 9 de junio, en el cual todas las partes acordaron, de acuerdo al decreto, que en 90 días la señora le daría $85,000 a mi cliente por el interés de por parte del interés en cuanto a la propiedad 3406 San Salvador. Y mi cliente entonces firmaría el título para darle a ella el interés. Sin embargo, han pasado 6 meses o ya más de 180 días y ningún pago se ha hecho. Estamos aquí para clarificar, debido a que el decreto de divorcio no menciona que si es que no se hace pago, entonces la propiedad real se necesita vender debido al cumplimiento. Entonces estamos pidiendo que podamos ejercer una cláusula para poder vender el hogar y la gente de bienes raíces. No creo que haya alguna objeción. Sin embargo, a la señora también se le dará la oportunidad de que si puede obtener el dinero, lo puede hacer antes de la venta.
I should have said, Mr. Montemayor, no.
Yo, that was expert level. They just completely forgot about the interpreter the whole time, and she just...
Do this now for the benefit of Mr. Garcia. We'll do this about 2 to 3 sentences at a time. Before I ask for a response from Mr. Garcia, Mr. Montemayor, to your knowledge, has any attempt to hire a realtor been made?
No, Your Honor. We've just been basically back and forth on status of payment and
understood. Translation.
But no realtor.
Abogado Montemayor, ¿se ha hecho algún esfuerzo para contratar los servicios de un agente de bienes raíces? No, su señoría, solamente hemos estado hablando una y otra vez sobre el pago hacia mi cliente.
Mr. Garcia.
So, Judge, to clarify, my client had been, from the time the decree was signed, trying to get the loan. And then some issues came up with at least one of her children. One of her daughters, the daughter that was here earlier, lives with her. The other daughter and her family had to come live with her as well.
Su señoría, para clarificar, mi cliente ha estado tratando de obtener el préstamo. Sin embargo, ha pasado ciertas cosas y una de ellas es que la hija que estaba presente ante el tribunal y la familia de ella han tenido que mudarse a casa con ella.
They're both adults, Judge. They're not minors. But regardless, she ran into issues having to help her children. And so she was not able to get the full financing that she needed. She's made several attempts. Various applications have been made to numerous financial institutions, as well as her employment. And she's made every attempt that she could to get the proceeds that were promised in the decree.
Su señoría, los hijos son adultos y ella ha encontrado, no ha podido financiar y ha hecho los esfuerzos para obtener el préstamo por medio de aplicaciones a instituciones bancarias y por medio de su empleo, y sin embargo no lo ha podido hacer también al ayudar a sus hijos.
So to clarify, Mr. Garcia, is Ms. Duran at this juncture claiming delay, difficulties, or impossibility?
We're not quite at the impossibility stage, Judge, but we're definitely having some issues and some difficulties obtaining the money that was promised in the decree. Mr. Montemayor and I have been discussing this over the past several months. We have been in contact with each other. We've attempted negotiations to try and settle it on our own. We've just the parties have been unable to agree to a set of terms that are acceptable.
Ms. Rodriguez.
Para clarificar, está su cliente diciendo que no puede o no puede con esto debido a dificultades o imposibilidad. Imposibilidad no, sus señores, sin embargo, dificultades sí en cuanto al dinero. El abogado Montemayor y yo hemos estado hablando sobre esto antes de venir ante el tribunal para llegar a una negociación y los términos. Sin embargo, ambas partes no están de acuerdo con los términos.
Well, it sounds like Mr. Montemayor is asking the court for a set of parameters going forward. If that's the case, what Mr. Garcia is your client requesting, and what does she believe would be reasonable and necessary?
Well, Judge, she would like to continue to try and obtain the financing, given the amount of time that's passed. Ms. Duran has already been in contact with a realtor to attempt to sell the property. If the court would allow Ms. Duran to retain the realtor, and in the time that the property is being posted for sale, if she's able to obtain the financing, well, then we just take it off the market and pay according to the decree. If the sale comes through before we're able to get the financing, then I guess we would proceed forward with a sale. But
Ms. Rodriguez.
Abogado García, parece ser que el abogado Montemayor solamente quiere delinear parámetros, que es lo que está pidiendo su cliente, que es razonable y necesario. Su señoría, mi cliente está pidiendo que se obtenga un agente de bienes raíces y que se ponga, o que ella contrate los servicios de un agente de bienes raíces y que se ponga la propiedad en venta. Sin embargo, que se le permita continuar encontrando la posibilidad para financiar, y si es que se financia o lo puede hacer ella, entonces se pondría la propiedad fuera del mercado para pagar lo que el decreto dicta.
So before I ask for a response from Mr. Montemayor, Mr. Garcia, how much time does your client believe at this juncture would be reasonable?
Your Honor, I think that's driven by the market. I mean, I don't know how long it would take for the property to be sold. I mean, she can sign it up with a realtor fairly quickly within the next couple of days. But at that point, once it gets sold, is a market-driven process.
Antes de que pida la respuesta por parte del abogado Montemayor, ¿cuánto tiempo está pidiendo su cliente y que ella encuentre razonable? Su señoría, eso depende del mercado. Puede ser que ella pueda contratar los servicios del agente de bienes raíces el día de mañana. Sin embargo, la venta de la propiedad puede tomar un poco de tiempo debido al mercado.
Mr. Montemayor.
Your Honor, we don't have a problem if she has a realtor. I don't think that's an issue.
I don't know what happened. They don't explain what happened. I don't know. I could be making all this up. This is what I know. They're probably near Laredo, Texas, border city, probably. And there was this $80,000 deal that was supposed to happen. And somehow just didn't happen. I know what I'm guessing. I'm guessing somebody was removed. Just plucked right out of their life, gone, and this is cleanup time. They're trying to clean up what was left here when that person was just removed. Again, I don't know that. I don't think I'm stretching though.
My client would have to sign on the listing agreement because he is part of the ownership. He's part of the title. So if we can have, maybe we can do this, as Mr. Garcia is suggesting. If we can just have a 45-day status on the sale, I think that would kind of keep us, I guess it doesn't fall through the cracks, I guess, in other words, and we'll be able to kind of feel where we're at. And again, if she comes up with the money in the interim, or we can work out some other type of an agreement, then it'll resolve itself as well.
Su señoría, no creo que mi cliente tenga algún problema en que la señora contrate los servicios de un agente de bienes raíces. Sin embargo, él tendría que firmar en el acuerdo debido a que es propietario aún de esa propiedad. Estaríamos pidiendo alrededor de 45 días para ver en qué estado o cómo están avanzando las cosas, si es que ella pudo obtener el dinero o si es que podemos llegar a algún otro tipo de acuerdo.
So why don't we do this, Mr. Garcia and Mr. Montemayor, because this court doesn't do statuses, because all the court can do at that juncture is hear complaints without giving resolutions.
Haremos lo siguiente, debido a que este tribunal no otorga audiencias de estatus, porque no podría darle a usted alguna solución y solamente estaría escuchando quejas.
So why doesn't the court order the sale of the property within 90 days of signing of the next order?
Entonces, ¿por qué no el tribunal ordena que la propiedad sea vendida dentro de los próximos 90 días después de que se firme la orden?
Failure to sell the home within those 90 days will effectuate a judgment for and against Mrs. Duran in the amount of $85,000 plus interest beginning on the date of the signing of the first decree,
That's a lot. What's
June
the
9th,
interest?
2025.
Is it 50% interest or 1% interest? What is it?
En la orden en la cual se diga que si no se vende la propiedad en los próximos 90 días, entonces se efectuará sentencia en contra de la señora Durán en un monto de $85,000 más los intereses intereses que se han acumulado a partir de la fecha de firma del decreto de divorcio del 9 de junio del 2025.
And what the court is doing here is just hitting reset on the process.
Y lo que el tribunal está haciendo es que está poniendo o reseteando el proceso.
And if Mr. Duran comes back and complains in an enforcement, that's what he's going to get in a judgment in any event.
Y si regresa el señor Durán y tiene una queja en cuanto al enforzamiento, entonces él está obteniendo lo mismo en cuanto a la sentencia.
Except that in this situation, you already know the outcome. Plus, you were given 90 days, I guess, free of any interest penalties.
Excepto que ya sabemos la solución final. Sin embargo, se le está otorgando 90 días sin penalidades a la señora.
This is your motion, Mr. Montemayor. Thoughts, comments, or objections?
No objections, Your Honor.
Mr. Garcia, same.
Your Honor, obviously, we'd like the court to consider not setting any interest charges against Ms. Duran. She's already having some financial difficulties. She's the only one caring for their adult children, Judge, and she's the only party between the two parties that's supporting the children that need the help. And so the burden is falling on her.
But these are adult children, are they not?
They are adult children. She's
Listen, Linda. Adult children are freaking expensive. They're very expensive.
Carrying the burden.
Translation, please.
¿Qué es lo que piensa, abogado Montemayor? No tenemos objeción, abogado García.
Every time he says translation, please, I look to JK.
Señoría, solamente le pedimos al tribunal que considere no penalizar con los intereses, debido a que ella es la única persona que está cuidando de los hijos. Aunque sean adultos, ella es la persona que está cargando con ayudarles a ellos. Pero ellos ya son adultos, sí, su señoría, son adultos.
That's it.
This morning.
So let me, I understand. These are going to be the orders of the court, Mr. Montemayor. This is your motion. These are the orders that are due on or before.
January 26th at noon by submission.
So this order is going to supplement the decree.
Comprendo. Sin embargo, estas son las órdenes del tribunal y estas órdenes deberán de ser entregadas por el abogado Montemayor debido a que esta su moción el día 26 de enero. Estas órdenes suplementan el decreto de divorcio.
Not a property will sell at 90 days after signing the decree.
Propiedad marital a venderse en 90 días después de la firma de esta orden o decreto.
So within that time period, will subject Mrs. Duran
Oh no, guys. Did you hear that? His microphone just got fried. And you listen, if you guys have ever tried to watch Juanita Jackson's courtroom, she's like right beside Fleischer, down the hall from Fleischer, across from Fleischer. You can't hear her. I can't record her because I can't hear her. It's horrible. His microphone. Oh, I love this judge. How long is it going to take him to fix this microphone? I can't get him anymore if it's like this.
Se vende esta propiedad dentro de 90 días, o a 90 días. Esto se separará a la señora a los intereses.
without waiving any defenses.
Sin poner a un lado cualquier defensa.
The court is going to ask if you require that to leave the wheelchair and blank. Based on what the court has heard here, the court is not convinced that Mrs. Duran has been able to secure the best and proper financing of the wheelchair.
Y le pidió al abogado Montemayor que deje en blanco el nombre de el agente debido a que este tribunal considera o está convencido de que la señora Duran ha por agente de raíces o ayuda financiera.
Anything else in this case, Mr. Montemayor?
Objection, Your Honor. Your Honor, I'm having bad connectivity issues.
The court heard no objections, Ms. Rodriguez.
Probably because you're driving, sir. Just my guess.
Mr. Duran, keep in contact with your lawyers. I wish you both very well. Have a good day. Any cases for Edith, counsel?
No, Your Honor.
Have a good day. Good to see you both.
Counsel de number 10.
Araceli Valdivia Martinez.
All right, hold on, because we were gonna spend a few more minutes with this judge, and let's see if there's. All right, let's just see if his microphone is fixed here. Hold on.
This is Maldonado, cause number 2024 FL.
Hold on. I'm gonna go back. I don't know what happens next. I got you the parts that I wanted to get you. But let's just see if there's another. Let's just sit with him for another few minutes.
Right, so we don't have family law settings on Monday, but the reason we hold court and allow persons, lawyers, witnesses, clients, parties to participate by video conference is to accommodate for situations like that. If you are working and are on the road, the only thing the court is going to ask is that at the time your case is called, pull over to make sure that you're safe and not driving. You can participate fully by video conference. But we'll accommodate your work schedule like that.
Okay, man. Thank you very much, Your Honor.
We'll see you here on February the 10th. I wish you well, Mr. Bouvier. Have a good day.
Thank you. You too, man. Thank you.
Those are all the matters for Counsel Salazar this morning.
It's good to see you, Ms. Salazar. Have a great day.
Likewise, Your Honor. Thank you so much.
Next online, Counsel Brenda Anderson, page 3, number 7.
Jose Israel Gaona versus Jocelyn A.D. Terrones, cause number 2024 FLI 1465C3. Court marks Ms. Anderson, present and participating by video conference. Ms. Leticia Garcia, present and participating by
Venus,
video
it's
conference.
Rita
Mr.
Skeeter.
Elias Alcantar, present and participating by video conference. He's here on behalf of the Attorney General's office. Are you Jose Gaona?
Yes, Your Honor.
Welcome to court, Mr. Gaona. The court marks you present, participating by video conference. As you can see from your device, your lawyer is also present by video conference. Are you Jocelyn Terrones?
Yes, I am.
Welcome to court, Ms. Terrones. The court marks you present and participating by video conference. As you can no, Ms. Terrones, do you have a lawyer?
I do not.
Oh gosh.
Are you going forward without a lawyer?
Stop.
Yes.
Sorry.
All right,
Yes,
the
I
court
am.
marks you, as you can
One more time.
Ms. Terrones, do you have a
One more
lawyer?
time.
Are you Jocelyn Terrones?
Yes, I am.
Welcome to court, Ms. Terrones. The court marks you present and participating by video conference. As you can no, Ms. Terrones, do you have a lawyer?
I do not.
Are you going forward without a lawyer? Are you?
Yes.
All right.
Yes,
the
I
court
am.
marks you self-represented. Ms. Anderson, announcement.
See, I love this
Good morning, Your
judge.
Honor. I'm here present for Mr. Gaona. Your Honor, I did file a motion for continuance in this case because we have a few matters that are still pending. Mr. Del Barrio urged or requested to be withdrawn as Mr. Rones' counsel last time we were here, but there was no order that had been filed. I did reach out to him and he did file it like moments ago, or just this morning, he did file his order. So we're just pending for Your Honor to sign that order so that then we can communicate with Mr. Rones directly. It was just unclear beforehand. And Ms. Garcia is assisting us in trying to see if there is a possibility to reach agreement and avoid a hearing. So we also needed time to kind of finalize that situation.
Ms. Garcia?
That's correct, Judge. I was requesting financial information from both father and mother, but I did not want to impose on Mr. Del Barrio's position that he had not yet been formally withdrawn from the case. I'd like also for the court to just inquire of Ms. Terrones whether she intends to seek further counsel or not, so that we can be prepared for that as well.
Let me ask the court clerk and coordinator, what was the date of the hearing on the motion to withdraw?
On December the 4th, Your Honor. It was granted in open court. Just their pending order that was filed today, Your Honor.
December 4th. I'm just asking so I can write it into that blank on that order. The court has signed this order. Mr. Del Barrio was withdrawn on that date. I've signed that order now. Ms. Terrones, will you at the final hearing date look to come with a lawyer, or are you going to represent yourself at the final hearing?
I'll be representing myself.
The court marks you as self-represented. Ms. Flores, does the court have Ms. Terrones' email address?
Yes, Your Honor.
All right. Ms. Anderson, Ms. Garcia, and I guess everybody, how much time would be reasonable and necessary for that final hearing? 30, 60, 90?
30, Judge, is fine. Brenda?
Take 30. Yes, 30. I agree with 30 days.
Give us a final hearing date that approximates 30 days.
February the 24th at 2 p.m.
All right, so you're going to come back to court on February the 24th. Mr. Gaona, do you have any questions for the court?
No, Your Honor.
Ms. Terrones, any questions?
No, I do not.
Thoughts, comments, questions, objections? Mr. Alcantar?
No, Your Honor. Thank you.
Ms. Garcia?
No, Judge, thanks.
Ms. Anderson?
No, Your Honor.
Mr. Gaona, Ms. Terrones, I wish you well. We'll see you on February the 24th. Good luck.
Thank you.
Thank you.
Thank you, Judge. That's all I have, Judge. May I be excused?
It's good to see you. Have a great day.
Next
you.
on live, Counsel Leticia Garcia, page 9, number 25.
Jenica Soraya Carrillo versus Jose Valentin Armenta, cause number 2025 FLE 976C3. Court marks Ms. Garcia, present and participating by video conference. Jenica Soraya Carrillo, Jose Valentin Armenta. Please step forward. Are you Jenica Soraya Carrillo?
Yes.
Welcome to court, Ms. Carrillo. The court marks you present in person. You are representing yourself, Ms. Carrillo?
Yes.
Court marks you self represented. Are you Jose Valentin Armenta?
No, he's my husband. He's adopting my children.
Understood. Sir, what is your name?
Manuel Perez Gomez.
Mr. Gomez, the court marks you present in person. Mr. Gomez, are you going forward without a lawyer? Or are you going to hire a lawyer?
He only speaks Spanish.
We'll begin Spanish language interpretation now. Mr. Carrillo, excuse me, Mr. Perez Gomez, are you representing yourself or are you going to hire a lawyer?
Pérez, ¿se está representando usted mismo o usted va a contratar los servicios de un abogado?
No, yo solo.
Myself.
Court marks you self-represented. Jose Valentin Armenta, are you present? Court finds. Go ahead.
I think it's a waiver of service, Judge.
Court marks Mr. Armenta not present. Court takes notice that a waiver was filed January 14, 2026. There's a question pending before the court. Is the Office of the Attorney General involved? Mr. Armenta?
No, Judge.
I don't believe so, Your Honor.
All right. Ms. Garcia, you are the court-appointed attorney ad litem. Are you ready to go
I am,
forward?
Judge. At the last hearing, the court would recall this was set originally just for a termination of two minor children of the parental rights of biological father. At that point in time, I did announce to the court that the intention of mother, after I spoke with her, was that we were going to convert this termination into a joint termination and adoption by the prospective stepfather, who is married to mother at this point. And I had a great conversation 2 nights ago with the parents, prospective, with Mr. Manuel, the 2 kids and mother. And yes, I am ready to give a recommendation that the termination be accepted, signed by the court, and proceed with the adoption. I'm confident that that is the right decision for the children in this case, and would ask the court, would the court prefer that I elicit some testimony, or would the court do the testimony from the pro se?
Just pausing for a little bit, Ms. Garcia, for translation to conclude. Ms. Garcia, you are the court-appointed attorney ad litem. Court finds that if you think that it is in their best interest, there is no conflict for you to elicit the testimony. Therefore, Ms. Carrillo and Mr. Perez Gomez, please raise your right hands. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth? So help you God?
Yes.
Both have answered yes. You may lower your hands. Ms. Garcia, 1 witness at a time, 1 to 2 sentences total. Go ahead.
If I may start with Mr. Perez, Judge.
On the termination?
Oh, okay. That's right. Let me go with mom. Ma'am, please state your full name for the record.
Jenica Soraya Carrillo Perez.
Ma'am, where do you reside?
At 505 North Martin Avenue here in Laredo, Texas.
And please announce and identify the children, the 2 kids that are the subject of the matter of this case.
It's Ricardo Angel Armenta and Destiny Shailene Armenta.
Can you give me the dates of birth, please, of both children?
Ricardo is November 22nd of 2016. Destiny is November 9th of 2017.
And who is their father, biological father?
Jose Valentin Armenta.
And is it true that you personally filed affidavits of relinquishment by and between Mr. Armenta and your 2 children?
Yes, that's true.
And is it also true, and I know whether you have personal knowledge of this, that I myself spoke with Mr. Armenta during the process of this case?
Yes, that's correct.
And are you asking that this court terminate the parent-child relationship between Mr. Armenta and your 2 children?
Yes.
Do you believe that because he had very limited visitation periods or possession or custody of the children that this is the correct thing to do?
Yes, that's correct.
Is it true that he never paid any child support for the children?
That is correct.
And that he never regularly visited nor inquired of the children, is that correct?
That is correct.
And for those reasons, you believe that it is in the best interest that determination be granted?
Yes.
Judge, if I may then move on to Mr. Bettis.
Go ahead.
Sir, please state your name for the record.
Manuel Pérez Gómez,
Manuel Pérez Gómez,
And where do you reside?
505 North Martin Avenue.
505 North Martin Avenue.
And how long have you lived with Miss Armenta?
Para 2 años.
It's about to be 2 years.
And are you formally married with her?
Sí.
Yes.
What is your date of marriage?
El 5 de mayo de 2025.
May the 5th of 2025.
Mr. Bettis, you have asked to become the legal father of Miss Armenta's 2 young children. Is that correct?
Sí.
Yes.
Do you intend to support those 2 children financially,
Sí.
Yes.
educationally,
Sí.
Yes.
and spiritually?
Sí.
Yes.
Do you understand that in the event of a divorce between you and Miss Armenta, you can be ordered to provide child support for those 2 children?
Yes.
Do you believe that it is in the best interests of these children that you be appointed their legal father?
Sí.
Yes.
Is it also true, Mr. Perez, that you and Ms. Armenta just recently had a baby?
Sí.
Yes.
And the baby that I got to meet is just 5 days old.
Sí.
Yes.
And that Ms. Armenta has an older child as well, who is, I think, 15 or 16.
Sí.
Yes.
And all of you live as a family unit together in the same residence, correct?
Sí.
Yes.
Are you asking the court to appoint you the legal father of the 2 children at this point?
Sí.
Yes.
Judge, it is again my recommendation that the court terminate the parent-child relationship between the 2 children and Mr. Armenta, and thereafter, of course, grant Mr. Bettis's request to be appointed father of these kids. I think there's an order on file as well.
Oh.
And that the names, the last names are set forth for the change of names to the children. And Ms. Armenta, if I get this right, the last names are going to be Carrillo Perez for both
Yes.
of the kids, correct?
Yes, that's correct.
We request that as well, Judge.
Sí.
Several questions. First question to Ms. Garcia. You are the court-appointed ad litem for the children in this case. Is there anything you want to share with the court regarding fees?
No, Your Honor. In fact, she did pay fees when I saw them a couple of nights ago. So that's settled. Thank you.
Next question, Ms. Carrillo Perez. I heard the birth dates. How old is your son?
9.
And how old is your daughter?
8.
All right. Last question to you, Mr. Perez Gomez. How long have you lived with the 8 and 9-year-old?
Como un año y 6 meses más o menos.
Around a year and 6 months.
Do they, what if anything, do they call you?
Papa.
Dad.
All right. And final questions. Do you understand that if the court grants the request, your obligations to these children are indefinite?
Yes.
Many people believe that their obligations with their children end when they turn 18 or graduate from high school. That's not the case. Parents have legal and moral obligations with their children even until they die. And then at the time of death, your estate has continuing legal obligations to your children. Knowing all of this, you want this adoption.
Yes.
All right. Ms. Carrillo Perez, Mr. Perez Gomez, in this case, cause number 2025 FLE 976C3, the court finds that it has jurisdiction. The court finds that respondent Armenta has filed a waiver. Having considered the testimony and evidence in this case, the court finds that there has been limited, if any, visitation between father and children. The court further finds that no support whatsoever has ever been paid. Considering all of these things and the testimony, the court finds that it is in the best interest of these children to grant the termination. Mr. Armenta's rights are hereby terminated. The court now turns to the adoption. The court finds that these two children have lived with Mr. Perez Gomez for a year and a half. The court finds that they call him Dad. Because in their mind, you are their dad. I get to do now legally what is going on in your house, and I get to grant this adoption because you are their dad. Congratulations.
Yes.
Give me a second to review your order so that I can finalize this adoption.
Yes, that was awesome. That was awesome. That judge is so good. Yes, absolutely. I'm going to get more of that judge if he streams. All right, guys. Thank you for coming out. I'm going to set up OJ now. And what is today? Today's Friday. So I am going to stream tomorrow morning, but I'm not streaming Sunday morning. I'm streaming Sunday night. Okay, so there's no OJ and no regular stream Sunday morning. It's going to be Sunday night. All right, guys. Behave, be good. I'll see you again real soon. Thank you so much for coming out. Bye, guys. I'm going to just go cry for a second. That was so good. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, she's got that grace. Come join the fun. It's a welcoming place. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in